Hello and welcome to Unpacking Contract Law, the UK-based contract law podcast delivering unsolicited opinions on new and old contract law cases. The purpose of these podcasts is to provide you with an insight into our thoughts, ideas and ideologies around all things contract law. It also provides us with an outlet for all our opinions, so you listen at your own peril. Each podcast will feature a new contract law case with a discussion from 3 contract law enthusiasts. And it is thus my great pleasure to introduce you to Maggie Hemsworth, Severine Saintier, and myself, Tim Dodsworth. Welcome to Unpacking Contract Law.
Sorry.
Severine, this is yours.
Good morning, everybody. Welcome to our 5th Unpacking Contract Law podcast. I am today the mistress of ceremony, giving Tim a little bit of a break. And today we are talking about the Supreme Court decision, Globalia Business Travel, or the new flamenco. So, briefly, the facts. The parties had entered into a charter party for 2 years when orally the contract was purportedly extended by another 2 years. However, so the contract, that further extension to the parties to end their relationship in 2009. However, Globalia challenged that oral agreement had extended the contract for another 2 years. And so they redelivered the vessel to the owners in October 2007. The owners accepted the breach, which was repudiatory, and claimed damages for that breach. For the loss of profit that they would have made during the additional 2-year charter. The owners then, when they received the vessel back, decided to sell the vessel, and they sold it for nearly $23 million US dollars. The value of the vessel at the end of the further 2 years, if the charter party had been really extended, had, following the financial crisis, significantly dropped and was around $7 million US dollars. So given the significant difference in value of the vessel, the charterer claimed that credit should be given to the profit that the owners had made. The parties were bound by an arbitration clause. The arbitrator said, yes, indeed, there should be credit should be given. This was appealed to the High Court, where Popplewell said no, there is no link between the sale of the capital value, and so it is therefore completely irrelevant. Appeal was made to the Court of Appeal, which said yes, the sale of the vessel was an act of mitigation, and so therefore credit should be given. And then appeal was given, leave to appeal was given to the Supreme Court, which effectively reinstated Popplewell's decision, and no credit should be due. In a reasonably short decision, Lord Clark gave the judgment, the leading judgment, but all the law lords, all the other law lords, Lord Neuberger, Muntz, Sumption and Hodge, agreed with him. So, quite a short decision, but quite an interesting decision, I find. So the decision effectively reiterates the importance of causation. Do you agree? Is that a welcome decision on that point? It does clarify the importance of causation. And I think on that it is welcome. But maybe you disagree with me. Maggie? Tim?
All right, I'll go. I think a number of things are interesting about this. Firstly, as you notice, there's 4 levels of hearing. So you've got a switch at each level. Yes, no, yes,
yes.
no. So that's interesting. So, one says it's a short judgment. You might infer from that it ought to be quite straightforward, but previous courts didn't find it very straightforward. The other point I think is quite interesting is it was pretty strong commercial background at the Supreme Court level. Severine, you referred to the judges there. They're all what I would refer to as sort of strong commercial sound, obviously experienced judges, but from the commercial bar or their experiences there. So for that reason and the unanimous nature of the judgment, you would view it as highly authoritative. You will guess that I would say on the causation point, which is your specific question, I see this as what I call Hoffmannian, and that's the word that I've invented. And so I would applaud that, I think, and so would Lord Hoffmann. I think he would say this is obviously correct. It's probably the way he would actually put it, where he's sitting on that panel. I think what is interesting, though, is the kind of sort of tangle that one can get into in terms of identifying the particular loss. Do you not think that? Sort of causation is a tricky subject, just generally, never mind for students, but just for anyone. You're trying to establish what the loss is. And so you're tracking back to a breach necessarily, because if you haven't got the breach, you haven't got the loss. So that's sort of all predicated on what is the nature of the breach. And so I would say, yes, this is obviously correct, because the breach was to do with an income stream, as the Lords put it. It's an income type obligation, that is paying chartering for a period of time. So the only loss that one really ought to be looking at, I think, is an income one, or at least in principle. And so I think one starts from a severe question mark over a capital value. What's interesting is I think Lord Clark rejects a sort of technique that we've previously had. That is the concept of benefits which are of the same or a different kind. You remember that in some of the older cases, they sort of distinguish consequences as a result of the breach. If it's of a different kind, then it's irrelevant to calculating the loss. And I think it's interesting that the Supreme Court in this one have sort of jettisoned that whole idea. So there's a whole great series of cases I think we would have to chuck out of the window on the basis of that. That it's too vague as a concept. And I think that's probably helpful to that extent, but you're still in a sense articulating it in terms of whether it's the same or a different kind, but we're using sort of different language, perhaps more precise language, I suppose. So this one, I would say this is a breach that gave rise to a loss of income, and therefore one must look for benefits gains that are of an income nature. But that's coming back to, loss of a same or a different kind, but other terminology. So I would have difficulty with giving credit for a capital value. And in terms of causation, I think there were 2 key points that one could pick out of the judgment that really sort of focuses your attention acutely on some facts. The first one that I think was particularly important was the fact that under these contractual arrangements, the ship owner, the claimant in this instance, could have sold the vessel at any time with or without the benefit of the charter. So that could have happened. And I suppose if we use the language of causation, that makes it a sort of the occasion for something happening rather than the cause of something happening. It's rather hard to get your head around. But in essence, the vessel, if it could have been sold at any time, what relevance, therefore, does it have that it was sold at this particular time? So the breach might have given them a reason for thinking more acutely about a sale, the occasion rather than the cause, but wasn't a main substantive consequence of the breach, because they could have done it at any time. And presumably in the shipping industry that does happen. You sell a vessel with the benefit of the charter, and the charter is still running, but the ownership of the vessel has changed, and it really matters not in a practical sense, because the purchaser is taking the vessel's ownership subject to the terms of the charter. So the charterer's interest should be fully protected. I think the other key point that I picked out was that if the market on sale was low in 2007 compared with 2009, when this contract should have run, the ship owner could not have claimed the lost capital value. And I think that's the sort of killing point. And I'm not sure that the Lordships sort of articulate this clearly as a guide for future, but I think this playing with the counterbalance, as it were, is a very good acid test. So, if you're playing with what the values would have been in the opposite situation, would that make any difference to the quantum of the claim? And I think that is a killing point, as it were. So I would pick those two key points out that support the argument on causation, that the capital value, is irrelevant to a claim for breach that has caused a lost income stream. So using the language of Lord Hoffmann in terms of causation, he might say their responsibility, the charterers, was to pay an income stream, the rent, if you like, of the chartering fees. And they've paid to that by their breach. So the capital value is wholly irrelevant to that. So that would be my take on it, I think. Don't know what Tim thinks.
Believe it or not, I think I agree.
Houston, we have a tiny problem. So I think I agree with you, Maggie. I find the language that I think you have summarized, the position very well. And I think the distinction for me, what is welcome in this decision. So I agree with you. I played a little bit the devil's advocate. It's a short decision, but yes, of course, indeed, because it has been going through, 4 sets of. It has been looked at 4 times effectively. Yes, it should be reasonably clear. But and indeed, I was quite amused as well by the yes, no. So I think in effect, what is really interesting is the language, which makes it clear in articulating why there is no causation. I think what you have said is something that Lord Clark said about the premature termination is the occasion for selling the vessel, but it is not the legal cause. So as he says at paragraph 33, the causal link fails at both ends of the transaction. And I think articulating it in terms of loss of income and then the capital value, and then highlighting that actually that's just indeed, they benefited from the property that they had, but indeed, if they had sold it at a loss earlier, that wouldn't have been taken into consideration. So on that, I think indeed this is a clear decision, and that has to be welcome if for no other reason than pedagogical, to try to help students actually looking at causation. And I think that's so capital value and income stream.
But then one just to jump in, one wonders therefore why there were 4 levels of hearing that went yes, no, yes,
absolutely.
no.
Well, I'm not sure that's surprising. Am I back?
Yes.
Yes, you are.
So first of all, I agree with Maggie, and that's quite unusual. So I think we need to highlight that right.
I think
right
you must
here.
be feeling ill. I think you're feeling ill.
It's the end of term. I think is must be affecting me. The first thing that struck me as well is the composition, of course, of the Supreme Court. I mean, you can't get much more market individualist basing this, and what have we got? The most certain. The focus on certainty here is and predictability is the focus.
Do those guys wear badges that says market individualist on them?
I would say so. I think there's a big neon sign above their head.
We shouldn't label people. I would call them strong commercial background. That's what I read.
Go on then. I'll go with strong commercial background. So originally that was my thought on this case. If I was looking at the kind of overarching picture here, it seemed to me on the one hand that the Court of Appeal was trying to say, well, we're trying to share the gains here. One party has made some kind of gain, and that we're trying to balance that against against the certainty point. The other aspect that I thought of in that context was, is the court trying to avoid some kind of double recovery here? Or well, on the one hand, they're selling the vessel, they're getting quite the profit, or it appears to be quite the profit, and on the other hand, they're then also going to get whatever they would have got if the charter would
but how
continue.
Can that, just to argue with you, how the heck can that be double recovery? Because it's an asset which they own.
Well, quite. So I think that's how I changed my mind as I was going through, because
I had forgotten that you were agreeing with me.
I was actually agreeing with you, possibly on a different. So on the one hand, of course, we know that if they would have sold it and made a loss, then they wouldn't have been able to recover that. And so my question was, where does that come from? Why is that the case? And I think on the one hand, it's, or probably for the main reason, that the breaching party doesn't have any input. Right, they have no way to influence the decision of the sale of the vessel or not. It's something that when I was first looking at the decision, I thought, well, okay, the breaching party is probably just simply not worth protecting as much here if we're trying to look at something below certainty. But the other one is,
but a breaching party never has control over how the other side is going to react, do they?
Well, exactly. And that would justify why we wouldn't want them to share the loss if a loss was made by selling the vessel. And I
think it's just far simpler that it's their asset. They can do what the heck they like with their asset.
Quite.
Yes.
Quite. And therefore...
But I also think if the breaching party is sharing the loss, then it is to a certain extent punishing them, which is not the aim of compensation. So therefore, that has nothing to do with it. I mean, I think it will be funny enough when you talked about certainty, that the badges of the law lords is absolutely clear, but yet they did discuss public policy. Popplewell is, impliedly in the decision, because they did refer quite a lot to his judgment, and where he did talk several times to issues of justice, fairness, and public policy, but precisely, the other way around, to ensure that the party in breach is just not going to benefit from, anything. And so Popplewell was quite strong in making sure that the, credit should not be given. But I'm diverting, and,
But just remember, this sort of high-level principles, justice, fairness, public policy, as you put it, they are so a high level of generality as to really not be of any help at all to be frank. I mean, that's the general aim of all of the rules that we fashion for all branches of law, and particularly contract law. The public policy one, though, is interesting because there are certain types of benefits that come following breach that, as a matter of public policy, are ignored, and so they are specific set of rules. So the obvious one that I know of, for example, is insurance policies, because that's sort of my area of interest, I suppose. Excuse me. So you can't argue that in terms of causation. That doesn't really work. You have to find some other rationale to justify why insurance policies that the claimant, the victim, as it were, has been able to recover. And that's done on public policy grounds, that they have made particular arrangements themselves to protect themselves by virtue of a contract with a third party, an insurer. And public policy would say, you know, you should reap the benefit of that. You've made the provision for it. We want to encourage people to make provision of that nature for themselves. And it would be wrong against public policy for the tortfeasor or the defendant in a contractual setting to reap the benefit of that. That might act as a disincentive to people to take out insurance policies. Similarly, we've got public policy rules on the same sort of argument for pensions, that people take out pensions. And it's a form of arrangement that you make for yourself, as it were. And so we end up using those sort of Latin tags of res intos alios or whatever it is. Severine, you'd be far better at me with the Latin on that one. You know, extraneous, if you like, irrelevant to the relationship between the wrongdoer and the claimant, as it were. That's a clear aspect of public policy. But reference to justice and fairness, that doesn't get you anywhere, does it? You know, if you were a practitioner, you would say, well, what rules do we have for that? You know, what am I to say to a client to advise them if only the rules are what's just and what's fair? No help at all.
Well, I would disagree with that, Maggie, because I think Clark, you know, you know, looking at my rough notes, you know, this has been mentioned 3 times in the, you know, short decision by reference to what Popplewell was saying, with no actual clear linked to cases. Actually, they could have simply said the aim of compensation, you know, stop at the causal link. There is no causal link. The aim of compensation, Robinson and Harman, is to simply substitute performance and not to punish the wrongdoer. But you know, the fact that after highlighting that you know, there is a need for a causal link between breach and mitigation and benefit. Lord Clark then refers to Popplewell by saying, of course, consideration of justice and fairness and public policy are also important. And here, this is when he adds, especially if the wrongdoer appropriates them. So here, there was a clear emphasis on the fact that the wrongdoer should not benefit and should not be given a credit. So in a way, we probably, by the fact that you are looking at it from an insurance viewpoint, maybe we look at it from a slightly different viewpoint.
I was only highlighting that as the classic instances for the ground of public policy. So if you put that on one side, the appeal to justice and fairness is not really specific enough for the law to provide clear guidance. It's fine, and I don't argue with those concepts at all. Naturally, I wouldn't. But they're at a very high level of generality and probably underpin all of the rules that we're trying to teach students in contract law and all of the rules in tort law. So where does that actually get you in terms of a concrete guide? It's dangerous, isn't it? Because if that's all that we had, we would end up with what a judge feels is right. In a
but we can end up in a situation, though, and this is where I think the high level part comes in quite nicely. Is we can end up in a situation where we get lost in the nitty gritty, where we're focusing so much on principle that we're actually losing what the aim of the whole doctrine is. right? And that's what we've got to remind ourselves here. And I think
Well, I agree. These are rationales and underpinning philosophies or principles, if you like. They're constantly used as a check on the precise rule that a court devises. That's fine. I don't argue with that at all, not an iota. But in terms of just using justice, fairness, public policy as a rule, it's not enough. It's not clear enough. It's not precise enough.
So what I was trying to do is trying to see where the judges are in this, in terms of these overarching concepts. What are they emphasising here in this judgment? And where I stopped was where I was on. Or the next step, as it were, in all of this, when I was talking about double recovery and all that business, I then shifted the focus to see, well, what obligations would this create if we did go the other way? And one of them would the failure to sell the vessel, for example, be a failure to mitigate? And that creates quite a dangerous precedent, doesn't it? We would then be in a situation where we'd say, okay, if you don't have an available market anymore, you need to find something else. Right, I let my house to someone, to a company. We're in the middle of the pandemic, therefore I don't have an available market. Do I now have to sell the property in order to mitigate my losses? That would create obligations that go far beyond what we would expect normally, and inject so much uncertainty, where we're back to the whole market individualist reliance on certainty. And I think that is one of the aspects that are so interesting in this case. Right.
Well, I would say, with due respect to the lordships, that's the one disappointing bit of the judgment, I think, because they are saying the same result is achieved, not arguing through causation rules, but through the rules about mitigation. But actually, the whole thrust of what they're saying in the judgment really is that mitigation is not engaged at all here. It's not relevant. We don't get into an argument about mitigation, because mitigation is assuming that there is a particular loss to which you can make some improvement on, as it were. So the only loss here, coming back to where we started, is an income stream loss. Whatever they're doing to mitigate that lost income stream, i.e. reletting the vessel out, rechartering it to a third party, that would be an act of mitigation, because it is in a response to a particular loss. If you're following, I'm not explaining this probably very well, but it's in response to a particular loss. So the word loss is not very helpful unless you stop and think, what loss are we talking about? And it can only be the loss that arises from a particular breach. So you're looking back, tracking back, what were they obliged to do? They were obliged to keep this wretched vessel for 2 more years and pay the chartering fees. And it is that loss, but only that loss, that is capable of being mitigated, if that makes sense. If you do something else that's not related to that particular loss, it's irrelevant. You can't even use the label mitigation. We don't go down that road at all. It's a red herring, if you like. So that's why I would come back to saying the sale of the vessel cannot be mitigation. It is irrelevant to the particular loss that they're claiming, because the loss that they're claiming is an income stream loss. So a capital activity, it just doesn't fall into any part of the rules that we have about mitigation. So that's the wee bit that when I looked at it, I thought, why are they not saying more clearly, not that the same result could be achieved through arguing the rules of litigation. Surely it would be better to have said, this is not mitigation at all. End of.
Well, I think they
do that.
I think they did, actually. They do say that, what I was referring to, the difference in value has nothing to do, precisely because the capital value has nothing to do with the interest which is injured by the charterer's repudiation. And funnily enough, I think they do spend a lot of time saying that this is not an act of mitigation. And, that's why they do explain in some detail the difference between the loss of capital and the loss of income. So I would say they do that. And, that therefore, when Lord Clark said that it fails at both ends of the transaction, it fails. And so therefore that is not an act. I think, funny enough, that is the one element that is clear and therefore also helps to understand why it has nothing to do. And so therefore to go into what you were saying, Tim, which I think is an interesting point as to whether they should have been actually, we don't have the details, but did they try to find another company to charter? We don't know that. No, they did, they took the decision. So I think in relation to what Tim said, whether in fact, one should be forced in order to mitigate the loss to sell the property, to take the example. So that's why I think here it makes clear that the two had nothing to do. And so therefore, perhaps that is one element which protects against the risk that, Tim, you were just talking about, precisely because they have nothing to do with each other. This is a pure commercial decision. And I think by highlighting that here they reaped the benefit that indeed they made a profit, but they also highlight at several points that they also bear the risk of the sale being at a loss, which has again nothing to do with it. And so I think that's the capital value of the vessel is purely at the owner's risk. And funny enough, I go back to my policy ground because I think that is quite interesting that, they do refer to it. And Lord Clark at paragraph 22 says, because the capital value of the vessel is at the owner's risk, to allow the charterer to appropriate the fruits of the owner's investment would be unfair and unjust. So again, here we go back to, we don't want to punish and yet, there are some interesting reference to policy and fairness.
And I think that's where the Court of Appeal judgment is so interesting. It seems that they're very worried about one of the parties really gaining. And I don't think, and this is, Maggie, where I agree with you, but I don't think there is a gain here. I mean, in money terms, of course, there is a gain in that they've sold it, and they've sold it for a profit, and they were wise, and they sold it at the right time. But it's a gain that is irrelevant in the grand scheme of things, partly because they could sell it. But one other thing that's... And it's short-lived, yes, of course. And it could have all gone differently. I mean, who would have foreseen the well, I think some people did, but the economic crisis that followed, that was not foreseen. So it was largely luck in what they did. And the other thing that I thought of as I was looking at the case was that it defeats the point to a certain extent of having an anticipatory breach and being able to accept that, in the sense that you now need to wait until the entire end of the period to see whether, or you would have to wait to see whether the other party has made a benefit or not. You'd have to see where the market drops or goes in terms of that. So that injects even more uncertainty.
And the law is quite clear that you don't
exactly,
do that, though,
because it disrupts the entire market, doesn't it? You want to be able to...
Well, the whole idea of anticipatory breach, surely correct me if I'm wrong, is to accelerate
exactly
that moment of choice, as it were, and they made their choice.
Yeah. So in that sense, it makes complete sense. And again, we're coming back to the certainty aspect. It undermines the whole concept of anticipatory breach, which is you can bring it to an end and off you go on your way. So in that sense, I think the judgment makes a lot of sense.
I don't know what you think. That I noticed there was the little point in Chitty on contracts that the editors of that have a wee bit of difficulty with the bit of Lord Clark's judgment where he says a sale might be relevant on the quantum of loss. If a sale took place during the term of the repudiated charter, then that sale might end the period for which the lost income stream has been sustained. In other words, the sale has ended the period of time running of your lost income stream, because you have converted, if you like, that income stream into a capital value on the sale of the vessel. So I wonder what you... Chitty says not sure about that, but I don't see why Chitty says that they're not sure about that, because...
So here, if they do take it as relevant during the period, then that reinstates that there is, the benefit of the same kind, of a different kind, and yet here they therefore seem to say that it would be relevant. So here, I didn't pick up on that, but that would indeed probably blur a little bit, because it's either relevant or not relevant.
Well, coming back, just to be devil's advocate, your fairness justice idea, all right, if we just run with that for a minute. If you've got a charter period of, say, 2 years left to run, and the innocent party sells the vessel on your breach midway through after a year, are you with me? That the whole argument is that early sale, if you like, has stopped the running of your income stream loss. You have decided to stop your losses running, as it were, and you're converting that into a capital value on the sale.
But that would have been factored in, right?
Say that again?
That would have been factored into the sale price.
Maybe. And so this is Lord Clark saying, it might have an impact on the claim, because we don't know what the figures would be on the sale. But, you'd have to look to see, has your sale price been affected by the fact that there was no existing charter running because they'd accepted the breach? Are you with me? So there wasn't a charter for the vessel at that time. So the purchaser would be free to do whatever they would with it at that point. But it also presupposes the state of the market at that particular time, whether there would have been a fresh charter possible, and if so, at what rate. So I think it's just Lord Clark playing with the facts and saying, although he's rejecting the capital value as having anything at all to do with the lost income stream, he does then say, but in some circumstances, maybe it would have an impact, because you arguably you have converted your asset but on the sale, so you've now got sale proceeds, and you have stopped the running of your lost income stream. You can't have it both ways. Just to come back to your justice and fairness argument, you can't have a claim for lost income for a 1 year period left to run when you have actually sold the vessel, and so you wouldn't have had that income stream.
But in your example, so to make sure that I follow you, Maggie, are you so?
Well, it's not me; it's Lord Clark. In fairness,
sorry. In fairness, no, but to make sure that I
it's an
follow,
exclusion clause. Now, I'm neither taking the credit nor the blame for this.
So to make sure that I follow, the example is given if there was a breach by the other part, by the charterer after 1 year.
Yeah, well, that he's saying if the sale is such, you could say that the sale of the vessel early has stopped the running of your income loss stream because you have decided to sell.
But is that following a breach?
That again?
Is that following a breach of the other party?
So if you've got a 2 year period of claim of lost income, which you are suing the charterer for, he might be able to say, hang on, you've actually sold the vessel at 1 year in of that 2 year period that you're claiming from me, and therefore you haven't got a 2 year period of lost income. you've only got a 1 year period of lost income because you have decided to sell it, and that has stopped the running of your income losses. That's the bit, I think, in the judgment that Chitty on contract says, not sure about that. But it wasn't part of the ratio. It wasn't part of the ratio. So it's just an aside comment.
Yeah, I think I'm not sure either, because whether there is a breach after 1 year, first of all, they wouldn't be claiming for 2 years. They would be claiming for the remaining year.
That's his point, I think. He's saying you couldn't claim for the full 2 years, possibly. As Tim is saying, you'd have to look at what difference it made on the sale, the fact that you've not got this running charter. But in principle, he says the sale during the period of the repudiated charter might end the period for which the lost income stream has been sustained. So you would be agreeing with that, Severine, from what you've just said. You're saying they wouldn't be able to claim the whole 2 years. They'd only be able to claim for the period up to the date of sale.
Well, as I say that in the sense that it's in their sale, the vessel, following a breach after 1 year, in which case, even if they don't sell the vessel, they would only be entitled to claim 1 year because they've only suffered.
Oh, no, it's a slightly different point. You're looking to calculate the total lost income stream that you're claiming as damages. And the question is, does a sale that happens during that period yet to elapse, would that make any difference to your claim for lost income? And so Lord Clark is saying, well, maybe it does, but nobody's asked us to look at that specifically in this case.
I think this potentially opens a whole kind of worms, and so therefore I would agree with the editors that I don't understand. I don't see why it would make a difference whether they stop if as on the facts here, they re-delivered the vessel, effectively at the beginning of the contract, the 2 years haven't run at all, then they can claim 2 years. If after 1 year they say, actually, we don't want it anymore, and then the other party decides to sell the vessel, that nothing has changed, that's still, the decision to sell the vessel, according to what their Lord Clark said here, it shouldn't have to make any difference. Well. So that is actually.
So you have a question over that. So, these are tangled things, aren't they? I think we would agree that thus far, untangling causation and applying it in particular factual situation. The rules are easy to state. And often quite hard to apply.
Yes.
Yeah, that is a really tough question, isn't it? Like, the more I think about it, the more we can really go down that rabbit hole, because partly is it taken into account in the sale price, if at all, because presumably if the vessel is sold, say it's a 2 year period, the vessel is sold after 1 year and there's no breach, then either they're going to assign the contract then to the new owners, in which case the new owners would claim, or they have some kind of deal where that's taken into account with the new owners.
It would be reflected, I think, in the agreed purchase price, whether you've got an existing charter still running, and also the market value for charters at that point. So if it has no charter at that point, the purchasers, what is their intentions on using the thing? So if they're looking for a charter elsewhere, it then gets complicated, doesn't it? As
really
to the availability of an alternative for them. So I think shipping can be rather tortured. Shall I put it that way?
Yes, I think it can. That's
wow.
So I just picked up, if anybody wants to look, Chitty, and I think I made a note the right paragraph. It's 26-107. They say this bit might prove controversial. This bit about a sale whether it has an impact on the end point of the lost income stream claim damages.
For us academics to pour over and agree or disagree with it, I think this is, to make sure that I don't make a fool of myself, because I don't actually quite, follow how and why he makes that point, because they emphasize so much that one is the income stream and one is the capital. One is the income stream and
well,
one
there
is
you go. You'd be
value.
agreeing with the editors of Chitty on Contract, and you would be in
I
hallowed company.
I think it's a way, given who the editors is, it's probably not about,
it's usually a safe position to take. Well done, Severine.
Yeah, it is. Yeah, no, but I don't quite understand why, there seem Lord Clark appears to be saying, look, this is not complicated. This is very simple. We can deal with it in 30
and then he makes it very complicated.
And then suddenly seems to reintroduce, that. So I need to actually.
I suppose could we say this for students or any happy listener who's still struggling with this? They've probably given up. They've probably given up 5 minutes ago. That causation and this sort of but-for test is often very tricky, isn't it? Because but-for is a particular wide possibility. Were it not for the breach, what would have happened? Well, how wide do you want to go? That's the problem with it, isn't it? And it's not your area, but actually, for anyone listening, that was the forefront of the recent insurance case, Financial Conduct Authority and Arch. So if anyone's interested in that's one where the Supreme Court had to look at causation in an insurance setting. And again, there they've said, the but-for test, I know tort law is keen on it, and we use it in contract as well for causation, but it's a bit, this is my language, not theirs. It's a bit of a blunt instrument because it can be very wide. If we assume that this breach did not happen, what would have happened to the claimant? What financial position would they have been in? Where do you stop? Because it's a domino effect with causation, isn't there? So there has to be rules of containing this, and but for is just so wide. So looking at this vessel, all of these things have arisen and wouldn't possibly have arisen but for the breach. But if we come back to the sale, I think the key point is Lord Clark is saying the sale could have happened at any time, regardless of the breach. So perhaps it's not satisfying a but for test if we apply those sorts of language to it, and he kind of is skirting around that, but he talks about it's the occasion for the sale rather than the cause of the sale, which is another way of looking at the but-for test, I think. But yeah, these things are not easy, isn't it? But we have to be careful that we don't have decisions that are based purely on justice and fairness. That's why I come back to arguing about that. Because, you end up doing what you think is right.
But, we've already talked a lot, and I think, it probably will be soon ending this, but we can revisit. I still think the judge can never do that, either in interpreting a contract, because either the clause is clear or, so the judge, I think the judges are very clear that they cannot interfere with a party's business, either when they are implying a term or when they are interpreting a contract. So I have, being a civil lawyer, being also trained in the common law, I can see that this is an argument that the English judges are very sure that they will never do.
Could we explore one more aspect that I just to be annoying? Be annoying again. If we let's go down the route. Let's go with the Court of Appeal's decision. Let's assume we that was the final say on this. And we look at the market at the time of breach, and let's say there was no market at the time of breach, but a year later, the market opened up. Right? The market opens up. Now, if
market for chartering or selling it?
Chartering.
Uh-huh.
So we're imagining a slightly different case. If we were to go with the whole comparison of what the ship was worth then and what the ship is worth 2 years later, and we're getting that into that difficulty, wouldn't that also mean that we then need to take into account that there was an available market for mitigating a year later? And therefore that would have to be taken into account, which brings back the uncertainty.
So what are you saying? If a charter was available at a later point,
yeah,
the income from that charter, yes, I would say, if I'm following you correctly, ought to be a set-off from the claim for lost income stream. So if you've got 2 years left to run on this charter, which has been breached, say, right at the early point, as Severine was saying, and you are able to find an alternative charter, say, 5 months, 6 months in, you have a replacement income from that 5 or 6 month point to whenever that charter ends, and possibly there is a following charter. So yes, that would be naturally, rightly argued, I would say, as mitigation, because you are replacing a lost income which you have had caused to you, suffered because of the breach, and you've replaced it with exactly the same sort of thing. It might not be at the same rate, it might be higher, it might be lower. So to the extent that it's lower, then the claimant has the benefit of that, as it were. To the extent that that's higher, then the wrongdoer, the defendant, party in breach, has the benefit of it. So yeah, I would say yes, in principle.
So what does that do then to our argument earlier on, where we were saying, well, that removes the whole efficacy of anticipatory breach, which will be at the moment in time of the breach?
That's only telling you, isn't it, that the innocent party, if we use that strange language, the party not in breach, has their choice to be made at that accelerated moment in time. So am I going to accept your breach or not? So I make my decision then. And then thereafter, all right, we start with the general principle. We calculate losses at that point. But I think, you'd probably know this better than me, but my memory is that's just a sort of starting point. It is possible for the damages to be assessed at a different date. And I think most courts would say we can't shut our eyes to the facts that have happened. And so that would naturally, I think, therefore be taken into account. So the rules about anticipatory breach ought not shackle the court, if you like, in terms of the assessment of quantum in an artificial or unrealistic fashion. Does that help?
Yep. Yeah, I think therefore that argument that we made earlier on might not be quite as effective. It was just a thought that came to me along the way. Bit disjointed, sorry.
Well, I suppose this is related to Lord Clarke's throwaway remark, as it were.
Yeah.
I think that's what he's saying. He can see that may well be a relevant point for some other case, but I don't think anyone argued it in this case, so we don't have clear rule about it.
Yes, I think there is definitely, I'm trying to think on my feet here, but I definitely think that there is, something to be explored in that throwaway comment, but also in relation to what it is that you have just argued, that the anticipatory breach is definitely a really different species in relation to calculation of damages, because also, we always say damages are going to be calculated usually at the time of breach. That is a rule which, has exception, and clearly anticipatory breach does. I have at the back of my mind a case, but I won't. No, I can't think of my feet because I don't have my everything. But I think definitely this is something worth exploring, showing the peculiarity of anticipatory breach in terms of assessment of damages.
Should it be that peculiar, just to throw a spanner in your works?
Agreed. I think that's a really good question.
Why should it have special rules about it? What's the justification?
Well, the point that Tim has just mentioned and that you have replied to, because then effectively the assessment is not done until the time remaining.
But we have that general rule anyway, so it's not peculiar to anticipatory breach. It's just as a norm, damages should be assessed at the moment of breach. That's the clear rule. For all types of breach, but it's not a hard and fast, it has to be in every particular case.
Hold on, say that again. That's what?
Well, no, but it is easy. If it's an actual breach, what happens afterwards is completely, irrelevant. And so it's easier to assess the damages whilst in. Well,
I suppose all I'm saying is there isn't a hard and fast rule that is in every single case that will be so, because there are some cases where judges say, well, this is the assumption or presumption that we work on, that damages are assessed at the moment of breach, but in some instances, because of the circumstances and because of the facts that we have seen has actually happened, that can be modified. And all I'm saying, I think, is that general approach applies also to anticipatory breach. So I'm just sort of querying to what extent should anticipatory breach have special rules, and to what extent does it have special rules? So I'm just wondering about that. That's all.
I think that's a good question, because the whole point of anticipatory breach surely is that you get the whole thing done and dusted early on so that the parties can get on with things.
And all it's done is to accelerate the moment of breach, if you like, from where you would naturally have expected to have seen it at the date of performance, when performance was due, to an earlier point in time.
Yes, but by the fact that they can take into consideration a known event, the assessment does not stop until. So, to take the point, if I understand what you are saying, Tim, so there is no available market at the time of the anticipatory breach. 6 months later, they managed to find another charter party. So it's 6 months since the breach. That is taken into consideration. Therefore, how long do they have to wait until they eventually find another charter party? So
these are just part of the general rules about mitigation, isn't it, really? So not an awful lot is expected of the innocent party because he's the innocent party, but he's expected to act reasonably. He can't predict the future. None of us can, although perhaps he would have specialist knowledge in his particular market. So as long as he's sensible and reasonable and sane, then the law is reasonably tolerant of what he does do or what he fails to do, as it were.
But it still imposes a duty on them, or an obligation on them, to continue looking for...
Yes.
Yeah.
Because the rationale, coming back to your justice fairness thing, the idea, this is fine, I accept entirely, because these are high level principles, because the rationale behind that is you can't sit on your hands and do nothing and load all the loss onto the wrongdoer purely because he is the wrongdoer. That is an uncommercial behaviour, and the law expects you to behave in a sensible commercial way, or justice fairness, as you would like to cast it. That's fine. So I think
I think it goes further than that. I think it's because the income stream would have been ongoing. you have an ongoing duty up until that point. I think it's. Also that's a fairness justice point, I guess. But the obligation continues because the contract would have continued, right? And so you can presumably offset the cost of looking for it against the continuous income that would have been. So I think that from that point of view, that makes sense.
I agree.
Yeah. What's interesting is that for 2 years, no market opened up.
So therefore, that's...
Just from a factual point, that seems hard to imagine.
Yes.
Doesn't it?
Well, I suppose,
Maggie, you'll know more about this.
Well, not really, but, shipping is a peculiar world. And sometimes the market is volatile and sometimes it ain't. And, that's what we've had, just to come off tack slightly with the Achilles, haven't we? That case about volatile shipping markets. I think it is a peculiar world, in a sense.
I'd love to unpack that judgment, by the way.
Yeah, well, there you go.
Well, maybe we need to, because that's the decision I was thinking about, and I can't. I'm desperately trying to open a document where the court made the point that, of course, this is an anticipatory breach again, and so the rules do not apply when there is an actual breach, and that's what But my word has frozen. So maybe this is the next.
It's never ending, this unpacking, isn't it? Once you start,
there will always be something to unpack.
There will always be something to argue and debate. No, debate was the word.
Debate. We're not arguing anymore.
So Tim and Maggie, thank you for when I finished reading this case, I thought, great, sorted, easy decision. And now you've just highlighted, actually, I don't know whether it is that easy.
Have we made it
very
worse?
Much. We have...
Isn't that our job? Isn't that exactly what we're meant to do?
What's that line? Where there is light, we shall bring darkness.
Yes. The film is coming to you soon, where there will be light, there will be darkness. Brilliant. Thank you ever so much.
Okay.
Goodbye, everybody. Goodbye, Maggie. Goodbye, Tim. And thank you for debating with me.